SJC-13577. Stephen Luppold versus Susan Hanlon et al.
Okay, Attorney McDonough, whenever you're ready.
Thank you, Madam Chief Justice, and may it please the Court, Miles McDonough, with me is my partner, Christopher Riley. We represent the defendant appellant, Susan Hanlon. Your Honors, I plan to spend most of my time on the new trial issue concerning the denial of cross-examination concerning bias associated with the high-low agreement. Before I do that, I just want to spend a minute or two on the other new trial issue, the issue concerning the so-called model instruction of the Superior Court on causation. There are just 2 or 3 points that I want to just quickly hit on this. The first is that the district court in May of 2024 updated their instructions on causation. They did it in premises liability and motor vehicle. And in both of those sets of instructions, they assiduously avoided the word impact. They did not take the path that the Superior Court form instruction takes. And I submit they did that for the reasons we argued in the brief. Second point is that we do ask the court's consideration of the jury question that was raised in the McDonough case, no relation, that came out of Middlesex County as well. That's an example of what we submit is going on out there in the jury deliberations rooms. There's a lot of confusion created by this instruction. That request for clarification was denied by the judge in that decision. That's up on appeal on a different matter. But the jury was obviously very focused and wrote a very cogent note pointing out the conflict between the had no impact prong of the third paragraph of the instruction, and we have it on page 19 in our brief, versus the other prong of the instruction that tells the jury when the defendant is supposed to win on causation. The second prong is the dual test. Of course, we have no problem with that. That is what should be done. It's the first prong that's problematic. And what I'd like to do is also just quickly touch on what I would call the end run problem of this instruction, the pratfall problem, if you will, that the instruction can lead a jury to find for the plaintiff on causation where dual would mandate a defense finding on causation. Here's the problem. Because of the way the instruction is phrased with that and in between, it's conjunctive, the jury could look at the first prong, the impact language, poses the question, it says if these two things happen, the defendant wins on causation. If the negligence of the defendant, quote, had no impact on the result, that's the first prong. And the second prong
that's not exactly what the instruction says, right? It doesn't say it further defines what no impact means. I can't pull it up right now.
No, Your Honor, the third paragraph says, if a defendant's negligence had an impact on Stephen Luppold's injuries, and this parallels the model instruction, then it caused those injuries. But if, this is the problematic language, but if the negligence had no impact on Stephen Luppold's injuries and the result would have happened anyway, that's dual.
And the result would have happened anyway, right?
Right, that's dual. We have no problem with that.
Isn't it defining the first part? I'm not saying it's as artfully done as it could be, but isn't it clear that it's defining what the had no impact means, meaning it had it didn't affect the result?
Well, no, I don't think so, Your Honor. It's reading it top to bottom, left to right. It's setting forth two requirements with the conjunctive and. And the plaintiff's position on this essentially is suggesting that there's a redundancy here. So, no, I don't agree with that point at all. And I think there's a real danger here because a jury, obviously the McDonough jury had a problem with it. They saw conflict in it. I think any reader could find conflict in it. And the upshot is, the danger is that the jury could stop on that first element and say, there's two things for the defense to prove here, or the two requirements for the defense to prevail on causation. The first requirement is had no impact. Impact means any effect of one thing on another. The jury could very well think, and may have thought in this case, that Ms. Hanlon's preceding negligence had an impact, if only in the slight sense that it slightly increased the chance that the second defendant, Mr. Lou Craft or the other fellow, that negligence caused the harm. So there's a little bit of mental
So
gymnastics.
in your mind, the solution would be to change the word "and"
No, the
to
solution-
"meaning."
The solution, Your Honor, is to cut out the third paragraph, get rid of,
But alternatively, we could change "and" to "meaning." It's as Justice Kafka was saying, it is the no impact means it had no effect.
I still think you're throwing in unnecessary language, Your Honor. I could still see a jury being confused by the word impact. It's inherently vague and confusing. So I don't think that would solve the problem.
So your solution is cut out the entire paragraph.
Just do what Dual said, like the district court judges are doing. Just stop with the but-for causation instruction, end of story. It's simple. And that's, I think, that would be helpful to jurors. Let me, Your Honor, turn to the other new trial issue. The plaintiff takes the position that the reasonable right of cross-examination for bias, particularly here bias associated with a high-low agreement, does not exist in the civil jury trials. That position, I submit, fails for at least three reasons. First, the genesis of that right is civil law. It comes from the Day versus Stickney case that is cited by no less than 6 of the decisions, the SJC decisions, in the notes.
Well, in the civil trials I presided over involving these parties and med-mals, so lots of examination over bias.
Yes,
It's
absolutely.
It's rife with it.
Absolutely.
I don't know the absolutist position
Well,
here.
there is bias. My point is bias because bias does arise in civil cases.
Every expert witness. We've got 10 minutes on
Right,
bias.
and that, I think that supports our point here, that the Massachusetts guide is correct in applying the right in both the criminal
Well,
and the civil context.
here's the issue I had when I read your brief. You say it's as of right, and it can't be diminished, but when I read 611B2, it says reasonable cross-examination show bias and prejudice is a matter of right. And you stop there, but then it says, which cannot be unreasonably restricted.
Your Honor, you've jumped ahead to my next point, that what does reasonable mean in context here? And we have the answer. I do want to just mention 2 other things. Article 15 means, for the reasons of the brief, we have to have this exist in the civil side as well. And it's absurd to say that in the civil side, we should be satisfied with a less satisfactory truth-telling mechanism. Cross-examination is the best truth-telling mechanism, particularly on bias and credibility.
Well,
So
no
the
one's
plaintiffs-
suggesting there was no cross-examination, right?
I'm sorry, Your Honor?
No one is suggesting that you were prohibited from cross-examination.
Oh.
The question, I think, is that you were prohibited from asking about the high-low agreement because you didn't tell the trial judge what inconsistency Lucraft had created between his trial testimony on either day or the deposition testimony years before.
And this is going to be able to answer both questions at the same time. If we look at the question of what reasonable means in context, that'll address Your Honor's question as well, because the test for entitlement as of right, get to the as of right part, is provided in the Aguiar case that cites back to the civil case that I just mentioned. The threshold inquiry a judge should be mindful of is it's a might test, a could have test. So if you look at 400 Mass at page 513, that's what I'm talking about. And it cites Stickney for this, Day versus Stickney for this proposition as well. It's a potential bias. If there's any indication in the evidence or in the circumstances that there might have been bias, that's what triggers the right to cross on it. And Your Honor, it was the failure of the judge to let cross-examination happen on the bias arising out of the concept of a high-low. And there are 3
But
types.
reasonable restrictions would include, important into a trial, the word settlement, right?
The reasonable, as a general proposition, Your Honor, settlements can
Right,
be
it's just-
excluded under the discretion of a judge, balancing probative and all that. That's
Right.
not this case. This case has inherent, and again, this is getting to the same point I want to make. There are 3, at least, that I can offer to the court, 3 inferences that arise as a matter of law from the mere utterance of the words high-low in front of a trial judge, okay? Let me give you 3 examples. Number 1, there's a quid pro quo inference. This is the most important thing that a defendant needs.
I get it when it's a the Mary Ellen agreements where.
Mary Carter.
Mary Carter, where you shift the responsibility to the other defendant. But this is, high-low is you're just bracketing. It's totally different.
It's not totally different.
And also, I read the excerpt for the trial. You don't ask the judge to sort of dig in here. You just say there's a high-low, and then I'm not even sure what your objection is at that point.
Your Honor, first, trial counsel did mention the fact that there were opinions that had been offered that had attacked his clients, number 1. Number 2, he mentioned the high-low. I'll get into the inferences that I want to discuss to show that there's inherent bias in a high-low. And number 3, he mentioned the insurance problem, okay? So there was plenty on the table for the judge to understand.
Really?
Here's a problem.
You can follow exactly what the trial counsel's objection was there, but, I mean, it's pretty incoherent, isn't it?
Your Honor, there's a typo that said, get him to bias. Obviously, what he was saying was get into bias. And it was on the heels of that those adverse opinions that had been offered. And so it wasn't unintelligible at all. He said, he mentioned bias. He mentioned the high-low. The nexus between the two is something that I submit should have been obvious to the judge for these reasons. Number 1, there could be a quid pro quo. Not only the high in exchange for the low, but also the high in exchange for the low, and also maybe getting some help from, giving some help to the plaintiff. Remember, this is a desperate time for this defendant. He needs his house protected.
Can
He
I
needs
just
his
read,
assets protected.
this is Mr. Kelly, right? That's the trial counsel.
Yes, Your Honor.
Mr. Kelly. The reason I asked to be seen, Your Honor, is the original more the prior testimony and getting him to bias of this witness and giving those opinions about the nurses because of his circumstances with his company and with the high-low agreement. I'd like to be able to inquire of that. I don't know what he's saying.
Well, let me explain, Your Honor. Change him to into, so he wants to get into bias. The context is, at the time, he had the record will show that there were opinions attacking his clients. And there were changes in testimony that align with the changes in interest created by the high-low.
What, do you have those changes?
All right, let me give you a few, Your Honor, and I do want to circle back to the nature of the high-low, why there's inherent bias in it, but let me give you the references. Volume 3, pages 150 to 151, that's Mr. Luppold saying at first, at his deposition, he said, I don't remember any conversations with Ms. Hanlon. And then at trial, at volume 3, pages 116 to 117 and 120 to 121, he says, now I remember when she was discharging me, I told her, my foot's swollen, my foot's purple, does that make any difference? And she supposedly said to him, you're being discharged.
So those are the changes in the plaintiff's testimony.
Which is part of the problem here, Your Honor, is because the plaintiff, after giving the high-low, the benefit to Lucraft, what's his financial motive? He has to turn his gun sights against somebody else who doesn't have the cap but has assets. He's looking to recover money.
And that change in the plaintiff's testimony, you identified for the trial judge so that the trial judge could make this informed decision?
I don't know that was spoken about at that precise time, Your Honor, but I know it's part of the record, and the judge is supposed to be. But let me address. It was
you expect the trial judge to know what the plaintiff testified to at deposition?
Because it was brought out on the trial record, Your Honor.
Right, it's part of the regular cross-examination anyway.
Right. But
You want another inference apart from he's lying now. You want a different inference. That he's lying because of the high-low.
Exactly.
Versus he's lying because he wants to win.
And because of the high-low, and most particularly because of the high-low. That's the realignment of the interest, Your Honor.
And the question I have for you factually is, if you know, was the high-low entered into before the plaintiff took the stand so that it would have the impact that you're suggesting?
What we know is the high-low was mentioned right before trial. It might have been mentioned years before. We don't know because there was no cross-examination allowed. But, Your Honor,
so instead of saying what you don't know, can you tell me what the record shows in terms of when the high-low was entered into relative to when the plaintiff took the stand?
Yes, Your Honor. According to the plaintiff's representation at the post-trial hearing, it happened sometime between the 10th and the 21st.
And was that before the plaintiff took the stand?
The plaintiff testified on the 13th. I believe those are the window dates. But Mr. Lucraft, let me get to the Lucraft stuff, Your Honors. Volume 2, pages 574 to 575, at that point, Lucraft, in his deposition, Lucraft had testified that he did not read the triage note, which was important because of the reference to the cool foot. It was critical on the diagnosis. At his at trial, I'm sorry, that was on March 10. That was during trial. He said, I don't recall if I read the triage note on March 10. 11 days later, same trial, after the high-low, he says, I did not read it. It was an important step that I skipped, and it violated my own custom and practice.
Was
So
there
he-
cross-examination on all these inconsistencies?
Was there cross-examination? He was being led by plaintiff's counsel.
I'm just,
On
on
cross-examination.
cross-examination, did all, my understanding based on the briefing, and I haven't read the transcripts yet, is none of these inconsistencies were pointed out.
Your Honor,
And-
I don't think that it's, that,
Were they? It's a fact question.
I'm sorry, Your Honor?
It's a fact question. Were the inconsistencies explored in cross-examination?
There were some inconsistencies explored in cross-examination, Your Honor. I can't
Were
recite for you.
these inconsistencies that you say are relevant to the high-low agreement, were they explored in cross-examination or brought out in cross-examination?
Luppold certainly was, Your Honor. I believe Lucraft's were. All right? But in any event, the judge went back to the deposition
You're
transcript
going to stand
post-trial.
up and say the opposite. You sure of that? Just to save us some time, or are you just speculating?
I'm not speculating, Your Honor. I'm trying to recall as to the, I can give you the record citations.
Well, but wouldn't that be important? Because you're beginning at the point of saying that you have this right to do so, but it doesn't, back to Justice Gaziano's point, the reasonableness of curtailing the cross-examination and the judge's discretion, that all of these things were, the inconsistencies were explored on cross-examination. So you're looking for a different type of exposure of bias or lack of credibility, where the counsel at trial could get into your testimony is different from your deposition versus at trial without getting into the high-low agreement. And so you're looking for something different. But how is that an abuse of the discretion or an unreasonable thing for the trial judge to have
Because
done?
under Aguiar and I believe other cases, Your Honor, the trial judge has zero discretion to totally cut out cross-examination on the subject.
He didn't.
He did. There's no reference. He said, quote, "We're not getting into any of that. We're not getting into any of that," meaning
Okay.
cross on the bias. That's the
So
whole
you're
point
talking
here.
about subject matter. You're not saying that the trial judge curtailed any cross-examination into all of the other things that might impact a witness's credibility.
Oh, that's not the point, Your Honor. The point
Well,
is the bias.
that's my point.
No, I understand. And I'm not saying there wasn't other cross-examination on credibility issues in the trial by any stretch. There always would be some. That's not the point here. The point here is the bias. Bias is special. It's not like a routine settlement agreement like in the Mitchnick versus Silberman case. Bias is the most important thing that jurors deal with. Bias and credibility. It goes to the heart of the right to jury trial.
Counsel, sorry, our time is really limited. Could you possibly please take a moment to finish your answer that you got interrupted in before about, you were, I think, going to say three
Yes,
sort of
Your Honor.
main problems with these agreements in terms of the kinds of
Yes.
things that you might be concerned about, and you started by saying it theoretically could be a quid pro quo. What else did you want to say?
Yes, and the quid pro quo, including not just the low, but the potential for helping the other side. The second is, it could be, even if there's not a contractual element to it, and the quid pro quo, by the way, could be written or spoken or a wink and a nod. The other aspect, the second is, if not contractual in nature, it could be simply considered a favor. Again, this goes to the point of how important a high-low is for somebody, a defendant in these cases. It's everything, okay? So if he gets this gift, this benefit from the plaintiff, he is by definition, virtually, favorably disposed to someone who gave him the biggest favor in his life. Even if that's all there is to it, that's bias. That's fairly explorable,
That's
precisely.
totally speculative. We have no idea, nor do you, what that high-low agreement, it could have been, he could have agreed to a huge amount of money, right?
Right, and it's a high, and it's a high, it's a cap, it's a liability cap, okay? And by the way.
And also it's a low too, right? He could
Right.
agree to pay a certain amount no matter what,
But the
right?
prejudice, the bias here arises out of the cap, the high cap, Your Honor.
Did we get to the
brass
third?
ring to get the protection of it.
Okay, let's get to the third thing that you were saying
The
quickly.
third, Your Honor, I would submit is a defendant who gets a high-low is going to be emboldened by reason of specifically the cap, whatever the number is, it doesn't matter. And we know high-lows are going to be, there's a high and a low, there's a range. It's not the ultimate exposure on the case. So it's to protect. And the defendant in that context is necessarily financially biased and moved to be emboldened, can be moved, to
Well,
be emboldened.
doesn't it depend on what the range is? If the high-low is, I will pay you a minimum of $39,000 and a maximum of $40,000,
Then
then
that's
there's very
probably,
little
that's very
incentive.
suspicious, Your Honor, because that's just keeping that defendant in the case to tattoo the other defendants.
Well, isn't that part of the question then?
Well, that's another piece of information that the judge withheld, ruled was not going to be available to the defense, and that would have been very valuable
Well,
information.
was there a request to the judge here to get disclosed to the defense the precise term, the co-defendant, the precise terms of the settlement?
Well, there was a cross-examination. He went up to sidebar and said, Your Honor, I want to cross on this. He wanted to take them on, get the benefit of cross-examination, which is instantaneous, immediate responses, spontaneity. Nobody gets a dry run, go right at it. And that's why, once you cross that threshold and you have a might situation,
But I'll defer to my
Then it's a
colleagues
matter
who are
of right.
trial judges, but isn't it an offer of proof? You've got to.
No.
Your Honor, we need to, this could be a fishy high-low. There could be something sinister here. We want to make an offer of proof on this.
Well,
None of that's happened.
well, in Monday morning quarterbacking, you can always ask, could that have been done? But it's
no, it's
cross-examination.
not Monday morning quarterbacking, because there's also an obligation that counsel has to have a good faith basis to ask the question that they're asking. So without an offer of proof or asking for voir dire, when you say, he could have had this, he could have been motivated by that, potentially could have been motivated by that, all of these don't satisfy a good faith basis to the trial judge to even ask these questions.
Your Honor, the good faith basis is satisfied once he has there might be bias afoot test satisfied. That's what triggers the right. This is not like a standard settlement agreement. You can't do an offer of proof in the traditional sense in this context. Why? Because the information is hidden from you.
You
The
could
cross-examiner,
ask for a voir dire.
I'm sorry?
You could ask for a voir dire.
May have been able to ask, but if he wants to cross-examine, he has the right to cross-examine, Your Honor. If he had to do a voir dire, it would not be a matter of right. That's inconsistent
Okay.
logically. He
I
has the
think
right to
I think we've-
cross-examine, not only upon.
I think we've covered it.
All right, Your Honor, if there's any issue about the emboldening, I'd ask the clerk to consider that too, as to what would happen
Thank you.
with such an agreement. Thank you, Your Honor.
Okay, Attorney Satin.
May it please the court, my name is Adam Satin, and along with Robert Higgins, I represent the plaintiff in this matter. I naturally, as you might expect, prepared where to start and go at least as far as I got, but just briefly where Mr. McDonough started on the dual issue, that McDonough case is a different set of instructions to a different jury under different facts. It is not a part of this record, was not part of any of the briefing. They made a motion, it was not allowed.
How about the language itself? Is the district court instruction a better instruction because it avoids potential confusion or not?
Respectfully, as I recall, they didn't brief the district court instruction. So with all due respect, the instruction that the model Superior Court instruction, based on a committee of trial judges who brought in a linguistic expert to evaluate and try to use plain language for jurors that they can understand, they came up with essentially the instruction that was given. And Justice Kafker, you're absolutely correct that the "and" that he's so troubled by absolutely just defines what's to the left of the "and."
But Justice Wendland's better articulation, should we be clarifying that, saying that meaning blank, as opposed to leaving it out there as an and, given, but again.
So I would suggest that Justice Wendland's comment about the wording and saying meaning, if you read it, if you hear it out loud, that's what the and says. It says, and just, it helps to hear it out loud, that if a defendant's negligence had an impact on Stephen Luppold's injuries, then it caused those injuries. But if the negligence had no impact on Stephen Luppold's injuries and the result would have happened anyway, then that defendant did not cause the injuries.
Does the and clause really solve the problem, though? Even agreeing with you that and essentially means meaning that here, if the problem with the impact word is that it's so vague that it suggests that a defendant could be liable if there was sort of any contribution whatsoever, no matter how slight, to the extent of the injuries, and then the and clause then means that the exact same injuries would not have occurred, but, I don't know that it deals with that problem.
So, well, I don't think it's a problem because it was drawn directly from the language this court used in Dual. The Dual court correctly said.
Well, we were moving away from substantial factor, which was a vague language that was causing some confusion here. So I'm not sure we were counseling the trial court to instruct with this impact sentence.
But
So most of the opinions devoted to but-for construction, right?
And the but-for construction was requested by the defense in this case, but the Dual opinion says we don't judge these instructions based on fragments of it. And that's what they're doing. They're asking you to look at one sentence, say it could have been better articulated, and the reality is that great effort was made to try and give a plain language instruction.
And isn't some of the issues that your opposing counsel is identifying with the word impact and its breadth solved by the proximate cause instruction?
So looking at, I think that the instruction as a whole makes clear what is necessary to find factual causation as well as proximate causation. It began with the defendant caused the injuries if the injuries would not have occurred without, that is, but for, that defendant's negligence. And then it goes on. I mean, that is the overriding principle from Dual, and the jury got it. This jury didn't ask a question. This jury didn't have a problem. By the way, medical causation was not greatly in dispute. The only expert they heard on medical causation was ours, who said there was medical causation. They want to create this issue of, well, it's really Lucraft and not Hanlon, but the reality is that the causation proof was absolutely, this wasn't something where the facts would lead to, she might have had a slight impact on the outcome. The causation proof that Mr. Higgins got 6 ways to Sunday, including with Mr. Lucraft, is if she had delivered the information she was supposed to deliver to Mr. Lucraft, this wouldn't have happened. He wouldn't have been sent home. He would have been kept. He would have gotten an ultrasound.
This was a he said, she said case, essentially. Where she either gave the information or didn't give the information.
I think it was pretty undisputed that she didn't give the information.
But that was the dispute.
Fair, and I do want to get to the high-low portion while I have time, if I may, but I'm happy to answer your question on that, Justice Gaziano. But it really was not a close call on causation. It was factually, did she have responsibility to deliver that information? And once she did, the evidence was this would have been avoided and the amputation would not have occurred. On the on the high-low issue, this court has long favored settlements and tried to have policies that favor and encourage settlements. The use of high-low agreements, particularly in medical malpractice cases where damages can be quite substantial, has allowed parties to proceed to the verdict with each party to the settlement maintaining their effort to win the case outright. And those have been widely used because it benefits everyone. Someone mentioned bracketing, I think Justice Kafka. This allows the plaintiff to guarantee some measure of compensation for what has happened for them. It allows the defendant to protect against seizure because the high level, which is...
It incentivates the plaintiff to go after the non-high-low settlement defendants,
Well,
right?
that was just mentioned, and with all due respect to Mr. McDonough, Mr. Luppold always had his sights on the nursing. Always. He brought the case, he pursued the case, he wanted to win the case. Mr. Higgins said no fewer than 5 times. They're all responsible. The jury agreed as to 3 of the defendants. The jury thoughtfully acquitted a couple of the defendants. But the reality is there was no, someone said it, Mr. Luppold's incentive was to win the case.
But when he changes, the plaintiff changes his testimony from the deposition where he doesn't remember telling anything to Hanlon to suddenly remembering clearly at trial after the high-low that he specifically told her, what about the
There's
discoloration?
actually nothing in the record to say that that was after the high-low, and the record is unclear about that. That having been said, this was a plaintiff who explained to this jury that when crossed by, it's the one thing Mr. Kelly crossed on, was that you said one thing and now you're saying that you remember this. What Mr. Luppold said is, it's been a long time. I see her in the court. I remember this. Jury could assess his credibility in that regard and did, I would suggest, and they rendered their verdict.
It can go it can go both ways. I mean, the presentation was it only helps to enhance the incentive to point the finger, but doing that could also work against the person pointing the finger, where the jury could say you're trying to bury the other defendant. So there can be another component, a tails to the high-low coming out as well.
I maintain again, from the second Mr. Higgins gave his opening statement, the sights were on the nurses. They were also on Mr. Lucraft. And frankly, that's why this case was such a clear-cut case of responsibility. Mr. Higgins had the benefit of being able to say, look, the only person whose fault this isn't is Mr. Luppold's. He reported certain important limb-threatening conditions, or symptoms, I should say, and nobody assessed it. No one talked to each other. And he said it was Mr. Lucraft's responsibility, and he said it was the nursing
One thing
responsibility.
I'm confused about, does Mr. Lucraft do a physical examination of the plaintiff? So wouldn't he see that the foot is purple? I'm confused by this.
The way that these cases are defended, it can be confusing. Because what Mr. Lucraft talked an awful lot about is, well, I don't remember this, but what my usual custom and practice would be to do is, well, of course, I looked at everything head to toe. His actual medical record, which you have, doesn't say anything about the feet. He interprets the medical record. The jury was free to accept his interpretation, reject his interpretation, but that record does not say, I looked at the foot is fine. It doesn't say the pulses on the foot is fine. It says something about the skin. It says something being warm. The skin, there's skin here too. There are pulses in the upper extremities too. There was nothing about the specific examination of the foot, and the jury would be well within its province to believe that since Mr. Lucraft had told them that he thought the whole issue was back pain, that had someone brought this critical information to him, you would have seen a heck of a lot more in that note about an examination of the foot. You would have had information that's now not there. They could have accepted that. They might not have.
Was the argument that Hanlon needed to cross-examine on the high-low because the plaintiff had changed his testimony to now point the finger more directly at her? Was that ever raised to the trial judge?
It was not, Your Honor. In fact, There was no suggestion at any time by Mr. Kelly that the high-low impacted Mr. Luppold's testimony. Mr. Kelly never asked to recall Mr. Luppold in light of this information about the high-low. As Justice Kafka mentioned, it's not remotely clear what Mr. Kelly was telling the judge was the significance of the high-low as to bias. And if I may, the cases cited on our brief, criminal cases, we can put aside whether cross-examination on bias is as important in civil as it is. It's important. We do it all the time. But the reality is that the criminal cases, Commonwealth versus Bui, B-U-I, Commonwealth versus Seeley, Commonwealth versus Mees, each of them has facts that are absolutely consistent with what this judge did and they say, this court has said multiple times, the proponent has to make a plausible showing of the bias that they're claiming in order for the judge to make a reasonable finding that they may have it. That's just basic trial law. To suggest that there is no discretion.
Without a voir dire or an offer of proof showing that this is more like a Mary Carter agreement than a standard high-low agreement, and that the plaintiff has changed his testimony between the time of he's first testified and later testified, that the judge can't evaluate this in any meaningful way.
And to your point, the colloquy consists of Mr. Kelly saying two things. The absolutely, to me, uninterpretable thing that says bias, whether you say into bias or not into bias, it doesn't clearly say why he thinks that high-low agreement is relevant to this case or to bias. And then he says he changed his testimony because his company is in rehabilitation. He said bankruptcy, it was corrected. But specifically, they said
the Woocraft's insurance company is in rehabilitation.
Correct.
Right. Okay.
And with respect to changed testimony, the judge immediately says, hold on, he said the same things in the deposition. How did the judge know that? Because Mr. Higgins had crossed Mr. Woocraft already in the case and used his deposition extensively. It was 3.5 years earlier, and he said the exact same things. You will not find any examination by Mr. Kelly of Mr. Woocraft where he brought one change to the attention of the jury simply as a prior inconsistent statement.
Apart from changed testimony, I'm wondering what you would require the non-settling party to include in a proffer, because they wouldn't know the terms of the high-low, right? What would be the mechanism by which they could make a proffer?
It would honestly be, first of all, there's nothing in the record to show he ever asked for any detail, frankly, about the high-low. It's not a Mary Carter agreement.
Would he be entitled to it if he had asked?
Certainly, he can ask, and the judge can inform and the judge can ask, and neither of them asked for details related to it. In medical malpractice cases, and this may be why, it's the high is usually the insurance coverage, the low is some low six-figure number, to be candid, and the verdict in between is the verdict in between. It's to bracket and to protect both parties.
We can't judge that. You're speculating. As far as we're concerned, you're just guessing too, because we don't know. We have. It's not in our record with this high-low.
It's not in your record, and that's because it was never aired, never asked.
It would make sense. That's where the high is.
Right. That's the whole point. That's why they're done. That's why not only do plaintiffs like it because they guarantee some compensation, they get to leave the justice system, whatever happens, feeling that they had a measure of compensation for their injury. Defendants like it because they get to not have their home subject to seizure. Insurance companies like it because they get to go to trial and see if they in fact win without taking that risk of their insured. Everyone likes it. You solicited amicus briefs and you didn't get any from the insurance industry.
Doesn't it work especially well because they can be guaranteed of some sort of recovery, a plaintiff, and then they can go after the other non-settling co-defendant full bore and focus on the person who has not reached a settlement, and then also have, potentially an unleashed helper in that regard, in the form of a co-defendant who has settled and who therefore can, be helpful.
So that's important because Mr. Lucraft was not an unleashed helper because he said things 3.5 years earlier, no change, but also when you read the transcripts, you will see he was not easy with Mr. Higgins on day one of his testimony, and he was equally not easy with Mr. Higgins on day two of his testimony as to his own responsibility. What didn't change at all between the two was what he said about the nurses. Simply, I would expect them to provide that information to me as the provider because it's so important.
So at a minimum, for a proffer, the defendant or the person trying to seek to put in the high-low would have to show that the non-settling, that the settling party is helping out in some way the plaintiff.
So there has to be some reasonable basis for the bias. And the high-low itself doesn't provide it. He's insulated now. He doesn't,
But that would be
the notion.
that would be indicative, or changed testimony would be indicative of that.
It could be, except there was none, but
Right,
it
but
could be,
I'm talking
but
about
also-
a case where we're trying to set parameters here, and I'm trying to figure out where the parameters are, when a judge abuses his or her discretion in this area.
Yeah, and just one thing, if I may, because the briefing, I guess, doesn't fully cover it. Mr. McDonough, for the first time in the brief on appeal, it was never raised before to the trial judge or otherwise, he raised the concept of, well, now Mr. Luppold, Mr. Lucraft can have the benefit of the high and he can seek contribution from the non-settling defendants. With all due respect, as these agreements go, as has been noted, this is about the insurance coverage that he gets capped on. He's not paying a dime. He doesn't have contribution rights because anything that he didn't pay that's paid by a carrier is subrogated to the right of the insurance company. So
But we don't
consider
have
what
any
he's...
of that in the record, right? We don't know.
No, because frankly, there's no evidence to suggest that contribution had anything to do with anything.
Can I go back to Justice Gaziano's question, and this is really about this issue in general and not the specifics of this case. Is there another context in which, in order to cross-examine on bias, we require a proffer essentially demonstrating the bias?
So the cases of this court that I mentioned, Commonwealth versus Bowie, Commonwealth versus Meas, M-E-A-S, Commonwealth versus Seeley, each of them have facts that essentially indicate that voir dire not only is appropriate, but was done in some of those cases, or could have been done and wasn't, as a factor that they found was a good reason why they didn't need to reverse the exclusion of the bias testimony. But they also all say that there must be a plausible showing of alleged bias with factual basis for support in order to allow you into that inquiry. And frankly, the judge has discretion in assessing that plausible showing. There just was none of any kind, and the judge was right on it, saying he said the same thing before the high-low as he did after, so what are we talking about?
So is your argument, in essence, that a high-low agreement is not per se sufficient in such a voir dire, just the existence of a high-low is not sufficient, but that if there were additional indicia on top of a high-low, that could be sufficient?
Obviously, if there is some good faith basis as to the bias, if it's made to the judge and the judge in his discretion allows the inquiry, that would be a very different case from these facts.
Right, so for example, if he had said at his deposition, Hanlon did not tell me anything, or the opposite, Hanlon told me about the note, and then at trial, day 2, he says she didn't, well, then you could get into the high-low.
If the offer is made and the judge, this is very similar to the...
Is there another possible way, which is he falls on his sword? Doesn't he fall on his sword a little bit here? Lucraft takes on more responsibility in his later statements. He doesn't do that?
He does not. He actually, he fights Mr. Higgins on his responsibility in both days, day one and day two. And frankly, you know, when, I do want to clarify, he makes certain admissions due to skillful cross-examination using a deposition from 3.5 years earlier.
I thought you, in your closing, if you were the trial counsel, said, and Mr. Lucraft stepped up and took responsibility, meaning he fell on his sword a little bit.
Well, look, he had a Navy veteran as a witness who was very different as a witness than the nurses in terms of credibility. Nurse Hanlon was an abject disaster, was never called back by Mr. Kelly to defend herself in a direct, never addressed the second day of ER care she delivered, not once. But in his closing, Mr. Higgins merely said, look, did Mr. Lucraft stand there and admit when I asked him that he should have read the triage, that he fell below the standard of care? Yeah, he did. And that's refreshing, but let's talk about what you got out of the co-defendants. This is done all the time in malpractice trials. You take something that is said that helps you, and you point out that the co-defendant is not the same way. He always said, and this has been noted to be important in other decisions, the ones that I mentioned, he always said, but I'm not letting him off the hook. He is responsible for this care, and he was found responsible. The courts that have decided these issues where bias has been restricted, many of them say, and there was other evidence of the person's liability from other sources to support the verdict. The trial judge in post-trial motion said her liability was, he had it 7 different ways from Sunday. He didn't say it that way. He said it in a way that was similar to that. Her liability was apparent all over the place. And so there is no basis to reverse this civil case given the offer that was made, the reasonable discretion of the judge, the reasonable limitation, when the general rule is that these things are not admitted.